she's just hoping for another opportunity.
She's hearing a drug case. Since the beginning of the case, she hasn't tested.
Understood, Your Honor.
You get the court thing cleared up, but then you had the other thing, and I still, for the time of year, I don't have a test on you.
I can go take one today. Is there a way that I can get somebody? I have my daughter here with me.
Ma'am, you probably shouldn't have done that. Ma'am?
Come on this way.
Ma'am, go with my bailiff now. Now.
Right here, the tone shifts from routine courtroom procedure to a moment of real consequence. Bringing a child to court while facing compliance issues immediately signals to the judge that planning and responsibility may already be lacking. In many courts, drug testing and compliance conditions are strict bond requirements, not suggestions. Do you think she truly believed she could sort it out later, or was this a gamble that sympathy might soften the court's response?
Thank you. In regards to the PCC, Your Honor, we are requesting an adjournment just for some continued negotiations.
All right. With reference to the violation.
Yes, Your Honor. Ms. Haynes is prepared to admit to the bond violation today and provide an explanation.
All right. I'll accept the admission, but what's the explanation?
Your Honor, it does state in the bond violation report that on the 22nd, when she reported she was visibly ill at the time, she explained to me that she has diabetes, and shortly after that went into DKA and did have to be hospitalized for a few days. So unfortunately, she ended up missing that new scheduled appointment as well as her first PCC. After missing the PCC, she did contact me, and we worked to get this case set to do a bench warrant recall. So she is willing to test. She is willing to comply on bond. She is sorry that she missed that appointment, and she's hoping to have an opportunity to go touch base with community corrections today and reschedule.
Thank you.
But I hear what you're saying, but when I look at this, all of the events that I have in this occurred at basically toward the end of September.
Yes, Your Honor.
I'm now almost 30 days out and nothing's been corrected.
And Ms. Haynes indicated to me that she wasn't aware that she needed to make contact with community corrections because she had the bench warrant.
I didn't know that I can just go back there and.
Yeah, but once the bench warrant was cleared, she still, that doesn't even make any sense to me.
They told me that I had to wait when well, first they told me I had to do it online.
Do what online?
For the bench warrant.
That's fine.
Yeah, and I didn't know that the warrant was cleared until I come to court today. And
What do
I
you
thought
mean
I
you
needed
didn't know it was cleared?
another referral to go back to community corrections. I didn't know I could just walk back in there and do it all over again with a warrant. I tried to come up here and walk in on a warrant, but they told me that they only do it once a month. At the end of the month on Wednesdays, and that would have been yesterday, but I had received
Yeah, but where were you between that? All of this occurred September 2nd. I get what counsel's telling me, that at some point you're in the hospital for a few days. So even if that takes me to the end of September, which is giving a lot of grace just in terms of time, I'm now here on the 23rd and nothing.
Because they told me that I could not walk in on the warrant. And I didn't know that I could just go back to community correction.
You have an attorney.
Mm-hmm.
And Your Honor,
I was contacting the attorney, and when I was contacting the attorney, she was telling me that she didn't even, well, it was a he. It wasn't even her. It was a whole different attorney I had. We were texting back and forth, and I was asking him questions, and he was saying he was in court. He don't know. He'll find out. And then he told me I could do it online, so I just did it online.
and Your Honor, I will say Ms. Haynes does want to resolve this case. She did make steps to take care of the bench warrant and to get the case back on track. So she's just hoping for another opportunity.
She's hearing a drug case. Since the beginning of the case, she hasn't tested.
Understood, Your Honor.
This is where the legal timeline becomes critical. Judges don't just look at a single missed appointment, they look at patterns. Even with a legitimate medical emergency like diabetic ketoacidosis, the court expects follow-up once a defendant is stable. The judge is essentially asking, what happened in the weeks after recovery? That gap can make the difference between leniency and sanctions. If you were in this position, what steps would you take to prove you were trying to comply?
I hadn't tested, Your Honor, because I didn't know that I could just find me missing mine. I didn't know that I could just go walk back in. I thought I needed another referral, or I would have went over there and walked in and
It's
tested.
not as though you didn't have an attorney, whether it be the previous attorney, whether it be Ms. Foster Tucker, to tell you what you could do regarding community corrections, if anything. But, you know, you didn't abide by community corrections. You didn't appear in court. You get the court thing cleared up, but then you had the other thing, and I still, from the time of year, I don't have a test on you.
I can go take one today. I can go over there right now when I leave here. But I just need to know, am I
You want to
assigned?
say, I will adjourn her probable cause conference to October 30th, 2025, 9 a.m. Anything you want to say before I send you on the violation?
No, sir.
Well, at this point, she's not complied with everything. I'm going to revoke her bond, sentence her to 7 days, Washington County Jail. Defendant's remanded.
Is there a way that I can get somebody? I have my daughter here with me,
Ma'am, you probably shouldn't have done that.
but she only had a half a day of school today.
Ma'am,
Come on this way.
they'll figure it out.
Okay. Let me get her this. Yep, I'll give it. One back.
Ma'am, go with my bailiff now. Now.
And here it is, the turning point. Bond revocation isn't meant to punish. It's meant to enforce compliance and protect the integrity of the court's orders. When a defendant shows repeated non-compliance, judges often see short jail time as a reset button to restore accountability. The request about her daughter underscores the real-life ripple effects of court decisions. Consequences rarely impact just one person. Do you think 7 days strikes the right balance between accountability and fairness, or should the judge have tried another alternative?
I omitted the.
Hold it. You know what, sir? Don't play fast and loose.
I got it.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too. That's how stupid your story was.
He is.
Really?
He's
No, he was not being honest. I mispronounce your name every time, sir. Okay, I apologize.
Thank you, Your Honor. Today is the time and date set for a probable cause conference. Regarding that, we are asking for an adjournment to show compliance with his bond conditions. I understand he's had a violation that we are prepared to deal with today.
All right.
Mr. Johnson is prepared to plead guilty to violating his bond by consuming alcohol on July 7th.
Let me, and I'll accept that. Before imposing any sentence regarding that, I'm going to ask this question. He presumably, he has indicated that he had O'Doul's. So my only question is, does your client wish to stick to that story, or does he wish to tell me the truth?
I believe that he would not be sticking to that story, that he would be stating that he consumed beer.
That's correct, Your Honor.
And why'd you tell everybody O'Doul?
I had O'Doul's first, but I needed beer.
You had O'Doul?
Yeah. I don't look like what I'm going through.
No.
I had O'Doul's.
Are
but
you
I had beer.
tell me that So did you tell them that?
Yes.
That you had O'Doul's first and then had beer?
Maybe I omitted the beers, but yes,
What?
I omitted the beers.
Hold it. You know what, sir? Don't play fast and loose.
I got you.
Story.
I consume alcohol.
I know that. You lied to them. Did you even have an O'Doul's that day?
Yes,
How many?
6.
And then how many beers?
2.
So why didn't you tell them that you had the beer?
I just omitted.
Pardon?
I just didn't. I was afraid of what might happen. I thought I could pass.
Yeah, I would be too, because you're violating your bond condition.
Indeed.
So first of all, we did the calculation because the only story you gave is that you had O'Doul's. To get to the level that you were at, you would have had to have 25 O'Doul's in an hour
No, I didn't have
in
that.
order to reach that level,
Sure.
and could not have used the bathroom because you couldn't eliminate in order to get to that level. That's how stupid your story was. And now you can't even bring yourself to say that you were intentionally lying to them and attempting to mislead them. It was not just a simple omission. Counsel, what did you want me to do with this case?
In regarding the probable cause conference, we're asking for a 2-week adjournment so that he can show that he's going to comply with the court's orders. I
Well,
understand.
I don't think he's going to have a choice on that, quite frankly, Mr. Allen.
We are asking for him to remain out of custody today. This would be his first bond violation. He is here to be honest with you, although the truth doesn't always make sense.
Really?
He is.
Really?
He's here.
No, he was not being honest. I asked him the question and then asked him the question of why didn't he tell them? And he couldn't even be honest about that. I'll let you go ahead with your argument, but I'm not buying any of that.
Your Honor, he is honest about the fact that he consumed alcohol, and he is very open to treatment. He understands that he has a substance issue and he wants to get help for that. Your Honor, he's a business owner. There's a lot of pressure on him. He provides for himself and his family. He also does volunteer work, not court ordered, just out of the goodness of his heart. He is open to treatment, substance abuse, counseling. He plans to seek that regardless of whether the court orders it or not. We're asking you to keep him out of custody with a scram tether. Again, this would be his first violation. And he is asking for the opportunity to show compliance while out of custody.
Anything from the people?
Your Honor, we do have some concern about Mr. Johnson's ability to comply with the bond conditions. As stated, this is his second offense. I think it's just a couple of years. We would note that in this case, he allegedly was found not awake in a vehicle that was in the street with 2 guns on him, although he's only charged with 1 CCW. So we do have some concerns about whether he's able to comply with those bond conditions.
Anything else?
Your Honor, I just think that he would have a better opportunity to get the treatment and help that he needs out of custody.
He first has to admit that he has a problem.
I
The
do.
way that he does admit that is he stops lying. Defendant's bond at this time is revoked. Defendant's remanded.
Subscribe now and comment below. Was the judge's decision fair?